Hi, I'm Campbell McLachlan, one of the three authors of International Investment Arbitration, Substantive Principles, the second edition of which has just been published by Oxford University Press. What we aim to do in international investment arbitration is, within the compass of a single volume, to state the general principles of international investment law in the way in which they're actually applied in the contemporary setting by arbitral tribunals. And that's not an easy task. International investment law is at least as important in setting the basic parameters for global prosperity as world trade law. But in contrast to trade law, investment law is not covered by a single agreement, but instead by well over 3,000 treaties, and not governed by a single dispute settlement body, but instead by a whole bunch of different arbitral tribunals, each one constituted for the particular case. So what we've had to do is to try to distill out of that mass of experience the general principles. It's about 50% longer, although we've kept the book within the same convenient compass of the first edition. Why is that? Well, partly it's because of the welter of new arbitral awards and also scholarly writing in the field. When we wrote the first edition, we were essentially writing on a greenfield site. There were certainly some new green shoots of development, but ours was the first major new book on the subject. 10 years later, a much greater depth of experience because the principles of investment law have been winnowed in experience in actual disputes. I guess the other thing which we've managed to bring to the second edition has been our own experience over the last decade, both in terms of our scholarly research, but also in our practice as counsel and as arbitrator. And we've tried to bring some of those insights from practice to the book as well. Well, we wrote this book aiming to provide a single analytical reference tool that could be used by scholars and students, by government officials and policymakers, and also by counsel and arbitrators involved in real cases. And what we've tried to do is to preserve the qualities that distinguish the first edition, which were firstly clarity of expression in a single volume, secondly intuitive organization of the material, thirdly presenting a balanced analysis, which is terribly important in this field, in order to show that we considered both sides of the argument, but not to shy away from being prepared to actually express a considered view on the toughest issues. And finally, we've sought to make the book a very useful reference tool through a rather meticulous approach to tabling and indexing. And for the second edition, we've cross-referenced all of the citations to the wonderful OUP investment claims database so that you can access the primary material directly. Since the first edition, this field has become undeniably highly controversial. And it's not simply because of controversies within the field on doctrinal issues, but also it's taken center stage in the public and the policy debate. And to some extent, I think that was inevitable, because after all, investment arbitration is there. Its very purpose is to sit in judgment on measures of states where they affect the rights of private parties, and to apply the external standards of public international law to state conduct. So it's actually all about the appropriate balance between public and private interests, and we shouldn't be surprised, therefore, if investment arbitration has a political dimension. We need also to reflect on the fact that despite the great growth in arbitration over that time, in fact, there have been significant developments more recently suggesting that there may be different ways of resolving these disputes. There's the EU suggestion that there could be an investment court. But I think from the authors' team's point of view, what all sides in this debate need is a dispassionate text that actually analyzes the underlying substantive rules. Because really, whatever form of dispute settlement is adopted, the underlying substantive rules still have to be understood and applied, and that's what we've sought to do in the book. Still think this field has enormous opportunities, both for legal practice, of course, but also great opportunities for the way in which, if properly applied, it can stimulate investment and therefore bring people out of poverty. The underlying idea of international investment law is actually terribly important for the prosperity of the world. How do we achieve that? In my view, the most important thing is to try to achieve a real consensus on common principles in international investment arbitration, and to integrate this specialized element of international law within the larger system of public international law.